Hello, my name's Sally Wainwright. I'm a member of WDI. I'm the Scottish country contact for WDI. And I'm also a founder member of an organisation called Lesbian Persistence, which I'll be talking about some more tomorrow. But today I want to talk about how much we have or haven't benefited from the Supreme Court ruling. And there are some references in this, so please, if I make references that you don't understand, just interrupt me and I'll explain them, because it's always difficult to know what people in the room already know. So the Supreme Court ruling, I think, was seen as a great victory, and indeed it deserves to be, because without it we'd be really in a terrible situation. But really I'm going to argue that far from being the end, and I think people were referring to this morning, it's very much only the beginning. It lays down an extremely useful basis on which to build, but as we're all aware, it's made rather less difference in practice than we might have hoped. The ruling states unequivocally that men don't count as women, and that we have the right to women-only spaces, services and facilities, etc. There's nothing wrong with the detail of the rulings. As Maureen said, it's a really detailed, really simple to understand, really clear ruling, and if you haven't read it, I commend it to you. It's a brilliant piece of writing. But the devil is in the implementation. And I think that there's going to be many, many more court cases or legal cases. I'm going to talk about using the law rather than necessarily going to court before we get anywhere close to re-establishing our rights. So there's three aspects that I really want to look at. Firstly, that the TRAs have been and are going to continue to argue against the ruling in every available forum. And they'll be looking for opportunities to take things to court. Those of you that have been following the Sandy Peggy ruling this week might have seen Fyfe's KC, the barrister, tell the court that the For Women Scotland case was only about public boards and has no relevance to the Sandy Peggy case. And they're really, I mean, every opportunity that there might be to try and undermine the ruling, they're at it. And I'm sure you all know that the case is about a male doctor being in the female changing room. And in fact, there's a paragraph in the ruling which directly addresses that situation. It's almost as if, because the Sandy Peggy case started in February and the ruling was issued in April, it's almost as if they went, let's say something about the Sandy Peggy case here, obviously without mentioning it. And there's a ruling, there's a paragraph which directly mentions it, and yet she's still standing in court going, oh no, it's completely irrelevant. For Women Scotland's got nothing to do with this case whatsoever. Secondly, many organisations who really ought to know better are tacitly or explicitly in some cases, as again we've heard this morning a lot, refusing to implement it, simply behaving as if the ruling didn't exist. And lastly, the effect of this is that we're going to have to be ready to take action ourselves. Not just legal action in the courts, but a lot of pre-litigation action. In fact, we're going to need to do a lot of things, everything we can, to avoid taking legal action if we possibly can, because going to court is difficult, expensive and stressful, and even in the strongest cases the outcome is not guaranteed. You may not all know, but For Women Scotland had to go to court no less than 5 times before winning in the Supreme Court. So it's, however obvious that outcomes seem to you and me, it wasn't obvious to many of the judges, and also at least the Scottish judges. And despite rumours to the contrary, J.K. Rowling is not going to fund every single case that we might think it's a good idea to bring. The number of times I've heard women go, oh, it's great, we'll get J.K. to fund that. No, that's not what's going to happen. So to start with the TRAs, I was actually chatting to Michael Ferran a couple of days ago in Dundee at the Sandy Peggy hearing. So I was asking him what he thought were the most likely challenges that the TRAs will mount. And he mentioned 3 in particular, generally using arguments about discrimination and human rights, albeit they've got varying prospects of success. So firstly, we can be sure that they'll be looking for ways to challenge the ruling directly by arguing that they're not being accommodated. They're likely to start with toilets, because it's an easier case to make than, for example, changing rooms. And their strongest argument will be to say, you're failing to accommodate me. You won't let me use the women's toilets, but I don't want to go into the men's. They'll probably try to argue their Article 8 rights. That's, I think Maureen was mentioning that a minute ago, their Article 8 right to privacy, which has been widely interpreted to include your right to dignity, to determine your lifestyle, or to develop your personal identity. And they'll also probably try to argue that it's discrimination on the basis of gender reassignment. I think that's quite unlikely to succeed, but you might have seen Robin Moira-White, a barrister who calls himself a woman, making a public spectacle of himself recently using the women's toilets. And there's quite a few people that think that he's deliberately being provocative in order to create a situation where he's going to be able to try and take a case, which he's also threatening to take to Europe. I think it's very unlikely that he's going to win any of that. But again, you can never be certain when it comes to the law. Secondly, we can expect to see a case brought by somebody with a disorder of sexual development on the meaning of biological sex. There is already case law on this. It was established some years ago in a case called Bellinger, but that could be challenged. Again, whether or not it would be successful is another question. And the third the third challenge that we're almost certainly likely to see is a challenge in Northern Ireland, because the Supreme Court ruling doesn't apply there. The Windsor Framework, which is primarily about Brexit, post-Brexit trade between the EU, Northern Ireland and the UK, but it also places, in general, it places EU law above UK law. But also, again, as Maureen said, the Equality Act doesn't apply to Northern Ireland, and the ruling was predominantly about the Equality Act, so that doesn't apply in Northern Ireland. But the ruling was also about the Gender Recognition Act, which does apply in Northern Ireland. And the application of the law there hasn't been adjudicated yet, so I think we can probably see that, expect that a case will be brought. And when any of these cases happen, they're all cases that we, by we, I mean the women's rights movement in general, might wish to intervene. And the advantage of an intervention is that it's a great deal cheaper, quicker, and less stressful than bringing a case ourselves. So that's always something worth bearing in mind. But the majority of issues that we face are going to be situations where organisations simply don't implement the ruling. And it's going to be down to us to try and force them to do so. Because if people can just get away with not implementing the ruling, and they just get away with it and they go on not implementing it, the fact that the law is different makes no difference. As somebody said this morning, it's not law if it's not applied. And they're relying on it being difficult, if not impossible, for us to take everyone to court or even to take them to task. So they think they can get away with it. Many organisations are procrastinating, saying things like, we're waiting for the EHRC guidance. There's absolutely no reason to do that. And there isn't any legal justification for doing that either. But they really are legally obliged to act immediately. The ruling clarified the law, it didn't change it. There's no waiting time for it to come into effect. And any organisation not implementing the law, or at least taking proper steps to implement it, because in some cases it will take time. You know, if you've got to review policies and things, you can't literally do it overnight, but you can start taking steps literally overnight. Anybody who's not doing that immediately is acting illegal. So, for example, in Scotland, the Scottish Parliament took quick action to ensure that it was complying. It changed the designation of various of its toilets to make sure that there was proper single-sex toilets and a separate set of gender-neutral toilets. But that's the Scottish Parliament, by which I mean really the building, the people who run the building. But in contrast, the Scottish Government was one of the organisations that said it was going to wait for guidance from the Equality and Human Rights Commission. In fact, it misrepresented a communication it had had with the EHRC, claiming that the Commission had told it to wait. It hadn't. It was exactly opposite to the advice that they had been given. And following pressure from For Women Scotland and Sex Matters, the Scottish Government has now changed its mind, and I'm going to say a bit more about that later on. Sex Matters has also set its sights on Hampstead Ladies Pond, which is run by the City of London Corporation. Because despite the Supreme Court ruling, Kenwood Ladies Pond Association plans to strengthen its policy by erecting signs to say that trans women could use the pond, changing rooms and showers. Very few organisations have actually made public statements that they'll ignore the ruling, because to do so would be to invite trouble. But we know anecdotally, and we heard some of those anecdotes earlier today, that many are carrying on as before. Academia, I think, is particularly prone to thinking it's completely exempt from the law. And in fact, again, I think Connie spoke this morning about a university that was blatantly refusing to keep men out of women's toilets. The Scottish Prison Service still houses around 6 men in the women's estate, which might not sound like a big number, but the Scottish prison estate is much smaller, of course, than the one in England and Wales. 6. The National Federation of Women's Institutes Equality, Diversity and Inclusion Policy says transgender women are welcome to join the Women's Institute and to participate in any WI activities in the same way as other women. Although this policy predates the For Women's Public ruling, it appears that the WI has not amended or altered the policy in any way and doesn't appear to have any plans to do so. But I think that a bigger problem for us as women is the vast number of small local associations that don't come under this sort of level of scrutiny. I was talking to a group of women about this recently, and several had stories of problems that they've faced. So one, for example, said that their local lesbian and gay centre allows Tims to join its lesbian meetings. And even with the ruling, it may be really difficult to force a change. There is a piece of advice that says that the best option would be for lesbians who want a lesbian-only group to set up their own parallel group, despite this being a lot more work than removing the single male who attends the existing one in this case. It is going to be difficult. There is actually, just as an aside, there is no legal basis for having a group which is for lesbians and trans lesbians, because the law allows you to discriminate on the basis of one or more protected characteristics. So you can discriminate in favour of lesbians who share the protected characteristic of being a lesbian. You could have a group that's just for trans women in inverted commas, men who say that they're women. Because they would all share the protected characteristic of being of gender reassignment. But if you have a group which has more than one protected characteristic as its kind of admission for membership, everybody in the group has to share all the relevant characteristics. So you don't have lesbians who also share the protected characteristic of gender reassignment. Well, I suppose you could have a lesbian who shares the protected characteristic of being, says she's a man or something. But I mean, basically, these two groups, that there's no overlap between the men who say they're lesbians and the women who actually are lesbians. They don't share protected characteristics. So there's no legal basis for a group. And actually, probably the best way to challenge that is for a regular straight man to ask to join. If you know any friendly straight men, and when they say, oh no, you can't, this is just for lesbians, he goes, no, well, you've allowed one man in and therefore you've lost your right to have any sort of criteria about not letting in other men, and therefore I want to come too. So a second woman said that she'd been denied access to a pride event because of her gender critical views. So the fact that the rulings there is not making a lot of difference on the ground, particularly in these organisations, the small organisations that don't think they're ever going to be challenged. I think there's also a potential threat, ironically, that the ruling, although it apparently gives us the right to single-sex facilities, will in practice reduce them, because many organisations might just not want the stress and hassle of working out who on earth is eligible to join and participate in women's services. I mean, obviously there are some situations where it's absolutely essential, rape crisis centres, for example, but trying to keep out the men who masquerade as women can be really quite difficult. And the easiest way to avoid that problem is simply not to provide single-sex services where you can. So, for example, a local swimming pool that offers women-only sessions might previously have been happy to risk a trans-identifying male turning up. But now it's clearly illegal for them to do that. And so they've got two options. One is to find a way to police attendance and make sure that no men claiming to be women attend. And the other is simply to say, oh, we're just going to make all our sessions mixed. We're not going to bother with this women-only stuff. It's too difficult. Doing that could open them up to a claim for indirect discrimination by women if you can show that she's particularly disadvantaged by the failure to provide a women-only service. But a lot of those organisations are going to be willing to gamble that there's not a woman with the time and resources to take that sort of challenge. So women will be self-excluding instead. And again, that's something to look out for. And if you see it happening in any of your local facilities, at least make a fuss about it. Go to the press or something. Just make it be known that this is happening, even if you can't change it I think it needs to see daylight. So what can we do to get a better observance of the ruling and to make sure that it can be is used to women's advantage? And there are many ways we can try and use the law to prompt action. So the first step is generally to write to the organisation concerned, setting out clearly and politely how and why you consider it's not adhering to the law. It's not a question of just writing and saying, oh, don't you know about the ruling? I'm very cross. You didn't let me in. You need to kind of go into quite a lot of detail about what the law says, the ways in which you think that the organisation is breaking the law, why you think they're breaking the law. I mean, it doesn't have to be pitch perfect because you're not lawyers, but you'd have to give a full explanation for them to consider. And Sex Matters has actually posted a template letter on its website, which you can use or amend if you want to do that sort of thing. If it's a local authority or other public body that you're writing to, you can write to the CEO, the complaints department, you can write to your local councillors and the chair of the relevant committees or departments, and a similar range of individuals for other public bodies. Offer to provide them with more detailed information or even offer to meet them to discuss it if that would be helpful for them. With voluntary organisations, again, the first step would be to write to the organisation. If you don't get a positive response, you could try writing to their funders with the same complaint. Now, hopefully, councils and other grant-giving organisations will insist that the grants that they provide are used in a lawful manner. I mean, obviously, we know that some of the funders are captured and they won't care, but again, it's always worth writing and asking. I think in general, there's a piece of work to be done with the large funders, the charitable funders, as well as the local authorities and so on, to encourage them to check compliance as part of their due diligence. I used to do grant assessments for quite a big funding organisation in Scotland, and many of the organisations applying for money, this was before the ruling, it was a couple of years ago, many of the organisations applying for money had equality policies that wrongly stated the protected characteristics. They'd obviously all been stonewalled. I always asked organisations to change this before recommending them for a grant, and I told them I couldn't recommend them for a grant as long as they didn't adhere to the law. But it wasn't a standard part of what we'd been asked to check as assessors, and I have absolutely no idea if any other assessor did the same thing or not. Nobody came back to me to complain. Nobody from the organisation I was working for came back to complain that I was doing it, so I presume it was okay, but neither did it ever pop up in any of our training sessions. In appropriate circumstances, moving on to things that you could do, you could consider contacting the professional regulator. That's what Mermaids tried to do in its unsuccessful complaint about the LGB Alliance, when it complained to the Charity Commission. On the other side, as Connie mentioned this morning, Sussex University was fined over was it 300? No, over £500,000, I think, by the Office for Students for breaches of the Office for Students regulatory framework, specifically for failing to uphold freedom of speech and academic freedom, again, particularly in relation to its treatment of Kathleen Stock. So that was a question of regulatory interests.
Sorry, who's it that fined them?
The Office for Students. You can also go to the regulator if you have a complaint about a particular individual rather than an organisation. Obviously, it all depends on the circumstances, what will be appropriate. And certainly we've seen that used to harass women often enough. Unfortunately, as with the funders, you can't rely on the regulator not being captured, of course. But some won't be, or not so much. And I hope anyway, that there will be increasing pressure on them to ensure compliance with the law. That is their job. Legal compliance is a very important part of their job. So hopefully they will start to try and implement it. Lesbian Persistence has written to the regulatory bodies about both Robin Moira-White and Theodore Upton, who's the doctor at the centre of the Sandy Pecky case. Neither of complaint has got very far. You'll be really surprised to hear that both the Bar Standards Board and the General Medical Council have said, nothing to see here. But we're working on it. Well, to be fair, the GMC said, well, they can't comment on everything until after the hearing the Employment Tribunal has concluded, which I think is right. And I think, having been listening quite closely to what's going on there, it's going to be quite difficult for the GMC to sit on its hands and do nothing. But again, we should never count our chickens. Another option, though less common, and I don't personally know of anybody that's done this, but I think it is something that might be in a toolbox, if you like, would be to contact the organisation's insurers, because they won't generally insure against claims where the company was knowingly breaking the law. Insurance is designed for accidental or even negligent actions, but not deliberate ones. So, if you, well, think about it in your car, if you're driving your car and you have an accident, you're insured. If you're driving your car and you're being a bit careless about the way that you drive your car and you have an accident, you're insured. If you deliberately point your car at somebody and run them over with the intention of, you're not insured. Okay. So, you can write to them and you can say, we've pointed out to this organisation that they're breaking the law. And are you sure you want to insure them against that risk of a claim? And who knows, even if you can't completely prove it, the insurance company might still want to fire a warning shot across the organisation's bows. But again, as I said, that's not something I've heard anybody doing yet, but it has been talked about. I think the insurance thing, actually I think insurance is going to be very, very important, because at the end of the day, organisations depend on having insurance, and if their insurers say we're not insuring you against this, yeah.
So just a quick question, like, how would you find out who they're insuring?
Well, that's one of the problems.
Oh.
I don't know. I mean, it might be in their annual report. I'm just saying what the theoretical things are.
So I certainly think that was an issue in sports, right? Because
yes,
for rugby, for example, if the risk is 40% of serious injury, what an insurer is going to cover that.
Shall I just finish what I'm saying, and then shall we move on to the discussion? Okay, well, I'll just finish what I'm saying. So there's several types of action available. Sorry, the last resort, I should say, is to go to court, and it really should be a last resort because it's very expensive and very uncertain. But the threat of court action alone can be very effective. In fact, the main aim of threatening legal action would be to push the organisation into action without the need for actually going to court. And I think the majority of these sorts of cases settle out of court, as we heard this morning, for example, about the Liberal Democrats. So there's several types of action available. The one that's been used by For Women Scotland, amongst others, is to take a judicial review against a policy. I'm just going to skip through some of this. There's 3 grounds for seeking a judicial review: illegality, procedural unfairness, and irrationality. But they're quite flexible, and there might well be some overlap. So as well as For Women Scotland using judicial review, in 2021, Fair Play for Women took a successful judicial review against the Office for National Statistics about the way that it was collecting information about sex in the national census. Another type of action would be to sue in the civil courts. The most likely action would be to take a case for discrimination under the Equality Act, alleging discrimination against you on the basis of your protected characteristic. Or you might want to allege an organisation has breached your legal rights. As you all know, if it's your employer that's breaking the law, then you can go to an employment tribunal. But you'd have to follow some internal procedures first. The main thing is that in any situation where you think legal action might be appropriate, is that you should always seek legal advice. And in most cases, before going to court, you issue something called a letter before action, which warns the organisation that you're going to take action if they don't do whatever it is you're asking them to do. And that's what Sex Matters did in the case of the Scottish Government. It sent them a letter before action saying you can't wait for the EHRC guidance. You have to be acting now, and we're going to take you to court if you don't do something within the next, I can't remember how many days. And the Scottish Government said, oh, right, fine, well, perhaps you're right, maybe we'll institute a review of policies and procedures, and we'll set up a short life working group. And Sex Matters said, well, that's very nice, we're very happy about that, but you could take immediate action to sort out the toilet facilities in your estate. So they've sent them a second letter before action and suggested a meeting, which the Scottish Government has now agreed to. So letters before action can be very, very useful. Again, probably that is something that's best drawn up by a lawyer. So the only thing I would say about letters before action is be wary of issuing them if you've absolutely no intention of taking further action and no means to do so, because it won't have any power at all if the recipient believes it's no more than an empty threat, and it will potentially destroy your credibility. So that's a very quick run through of the types of things that we can do. I certainly didn't cover everything possible, but we are planning on producing a guide to the types of actions that are available, not just the legal actions, but the ways in which you can use the law, because all the things that I've been talking about are talking about using the law, albeit without going to court. So Maureen and I and Sarah Tambern, I think, are going to be working on trying to produce some kind of guide, which will help with that. So we want to encourage women to take action, using the law as strongly as possible to make our point. And I think I'll probably finish there.
Before we open it up for discussion, I did print off copies of the response that we did to the For Women Scotland, the Supreme Court. So if you go onto the website, then you can see the End Sex Falsification Restore Safeguarding campaign, and then this is that Maureen rewrote after that. So please take a copy. So if we open it up to discussion, yep.
Right, okay, thanks very much. I mean, it's really interesting to hear about the legal aspects of it, which you're going to need to look into even further. Is anyone aware of a report decertifying legal sex? I mean, decertifying legal sex. It was a 5-year study funded during the COVID period. It was started by Theresa May, and Boris went on ahead with it. And the idea was, in order to decertify legal gender, they would have to certify legal sex. Now, ask yourself the question, why is that? Because the actual answer leads to, and in my opinion, the creation of what is known as 15-minute sanctuary cities. And if you look at every single political party being involved in this, every single political party has allowed the civil service to actually bring in, fund organisations since the Miller inquiry, fund loads of organisations, trans organisations, and civil service focus groups to actually look at how we can decertify legal sex through, in case we decide to abolish the GRA. Foreign's not unique in this. We know he takes stuff from other work, other people's work. But the idea is, with 15-minute cities, is you basically create a localized surveillance society through digital ID, where the idea of collectivity and solidarity is gone, i.e. feminism is gone, right? So everyone's equal in these 15-minute cities, everyone. The collateral damage is, of course, women, because we're not equal. And so if you have a problem, say domestic violence, men and women are considered equal, lower levels of service provision, because in these 15-minute cities with outside backers and funders, you're going to have smaller services, smaller toilets, smaller facilities. So hence, that's why they're trying everything in there, but within their ability to bring men into refuges and so on and so forth. And that is the problem. And that's not going to go away, because when I started mapping all this, and it all leads to 15-minute cities, I actually went, Julie was with me, to under the guise of a Sylvia Warby lecture, to see the author of this report, Decertifying Legal Sex, who used to be chair of the Women's Committee in Haringey, where I used to work in 1987. Davina Cooper is her name. And I said, oh, what's happening with that report, Davina? She goes, oh, we've suspended it for the moment because society isn't ready for it. It's still there. It's still there. And they know that the casualty is going to be women. They don't care, because they're going to make some names for themselves. And it was funded £600,000 EHRC grant. So, yeah, we can go for all these sex falsification. It's not going to happen, because they are going ahead with these sanctuary cities, decentralised local government, digital ID, surveillance societies, where a man can say, I'm a woman, I'm a victim of domestic violence, mixed service provision. That's how it's going to be dealt with. It's going to get rid of collectivity and solidarity. It's all about the individual.
I think that's a really interesting point. And also, it's not just in the UK. I mean, I went to talk about this, that Sandy Brinkley's partner gave, whose name completely escapes me, she's an
Sharon
academic, Sharon Cowan, gave some years ago, where she was talking about decertifying sex. And in fact, there's an article in the WDI book, Women's Rights, Gender Wrongs, which is about decertifying sex in South America. So it's definitely a widespread movement, and it's something that I agree with you, we need to be aware of.
There is,
Right,
the
can we-
whole concept of astroturfing was created by this paper.
Okay.
Sorry, I can't hear, that's why I moved up.
It's nothing, we won't let it happen, Georgia. We're not going to let it happen.
Huh?
You know,
No.
we can't let it happen.
We can't let it happen.
Let's
no,
move
but
on to some other
you can have
questions.
endless judicial reviews, it's not going to get you anywhere. You need to target it, and we need to be solid.
Yeah, okay.
We need to have solidarity, and we need to be more militant. That's my point.
Right, thanks, Georgia. Yes.
Rory mentioned that when you have a group like Henry, which is a lesbian organisation, and there are trans-identified men in it, they have a legal duty or obligation to ask their membership if what way the membership wants to go. Is that am I right?
I'm not, you mean, not necessarily following the Supreme Court judgment. To be honest, I'm not 100%. My knowledge of organisational regulation is not very deep, so I don't want to give a wrong answer to that. So I'm not going to say
But you
it's
did
right or not. But they could have it completely women only.
because I think you went on to say, Sally, that actually you can't have it two things at the same time that are contradictory. So
Yeah, that's correct.
whereas they're saying we're lesbian only organisation just for lesbian women, but they've also got trans-identified men in there. That I think they're
If they're claiming it's
Yeah.
single sex, they can't. have
Yeah.
trans-identified
It's very
men
it's
there.
very difficult to enforce.
Yeah.
Is the problem? But it's true. There is no legal basis for it, so it can be challenged.
good.
Okay, Julia. Julia.
Yeah.
Yes, thank you, Julia. One of the unfortunate things about being trans widow is I look at the horrible surgery. Has anybody heard about Dr. Joseph Chrysostom, who has written to the Royal College of Anaesthetists recently an open letter, it's available on Twitter, asking anaesthetists as a group to refuse their services for gender reassignment surgery, calling on them to look into their ethical framework. I find this extremely interesting. And if you can carry that across to the American context, it means the insurers will no longer fund this. I think we're going to get eventually into a position where we can at least put the really mad men, like my ex-husband who's now dead, we can stop their surgeons and the anaesthetists from pushing them over the edge. And that matters because without this goal, what are they seeking? I think this is an important element that we should consider, please. Thank you.
I can diagnostic bots will get rid of all of that.
Yeah, you are.
There's a question online from Alison Jenner. Shall I just read it out, Alison?
Yeah.
It says, can women ask the EHRC to carry out enforcement re single-sex spaces and associations? My understanding, Maureen might have something to say about this. My understanding is the answer is yes, but whether they actually will take action or not is a whole other matter.
That's my understanding.
They've got the power, but they have very few resources. In the past, they probably had very little. Well, I did have some success with them. There was a little personal victory actually, because I complained to them in the context of talking to them about something else, that the women's library in Glasgow was advertising a job for women only and defining that as anybody who defined as a woman, and they did actually go to the library and come back to me and say yes, they will now be making an appointment in accordance with the law, which I was very pleased about. Yeah, but I've asked them again for other things and they've ignored it, so they will occasionally. Emma,
Sorry, it was
Julia and then Emma.
Thank you both, really interesting. I was thinking really about that last, one of the last points you were making there, Maureen, about the protections for this, on the basis of gender reassignment or whatever it is, and you mentioned possibly housing or possibly employment. I really fail to see how these men should have any protection regarding any sort of employment, whether they can be proved to be a risk to women or children or not. Because if we if we look at what they're doing, I don't see that the right to impersonate another group should be in any way protected under law. So I just question that we should even be thinking about that as a reasonable thing. And in terms of housing or any other sort of aspects of life, there are lots of things that aren't protected. Like if someone identifies as part of the kink community, or they're into, or they love watching porn or something, they're not protected. So I don't see why this, if we're saying this is a paraphilia of some kind, I don't see why that there's any rational basis for any sort of protection. It doesn't seem that. Just to finish, but obviously you can come back to. But also, I'm increasingly really wary about this term paraphilia, because I think it puts it into a sort of medical frame, and we know now we're in the age of diagnosis. People are getting diagnoses for all kinds of things, and then getting accommodated on that basis. And so I think if we think of this man who is performing his what he's even the word fetish, I think even the word fetish, I think it puts it at one step removed from this man. He's performing his decision to get sexually aroused through this performance. And I think as soon as we say he's a man with a paraphilia, he can say, oh, it's my paraphilia. It totally lets him off the hook and removes his accountability. Right. Do you see what I mean?
I see what you mean, yeah.
That's why I'm really wary of saying that, because as soon as you can say I've got this thing, that's basically.
I think we should describe. Have you got a suggestion how we could describe that instead? Then I take it first.
Anyway, well, I think we can think about it. I would say it's a form of sexual entitlement, like all the other forms of men's sexual entitlement. That if a man wants to go and use a woman in prostitution, he's not protected. So I just think as soon as we put it in that frame, to me it clarifies things.
Yeah, okay, just to get back to the protected characteristic issue, and I see what you're saying, and I've got quite a bit of sympathy with it, but I think as well, we have to take account of the fact that we've also, as far as the law is concerned, talking about women who think they're men or want to claim to be men, and who look, more, whose dress is more masculine, or who may have taken testosterone or whatever and who look masculine. I wouldn't want to see them lose protections against housing discrimination, for example, or certain types of employment discrimination. And I can't see a way that we could get away with anyway, where we could protect those women and not have some kind of employment protection, or certainly housing protection for men claiming to be. So somebody was refused housing. If somebody's refused housing on the basis of their clothing, they're dressing like the opposite sex, just to look at it in a minimal way. Are we saying they shouldn't have any protection from that in law at all? Do you see what I'm saying?
But look, half of us are here all wearing clothing that are,
I know, and that might be sexual orientation discrimination for a lot of us.
I don't think that people really get refused housing because of the wearing a pair of trousers.
No, it's not just about wearing a pair of trousers.
Someone presents is basing it on like a protected characteristic on how they dress or the colour of their hair. Like sexual character or sexual orientation and sex-based discrimination is already covered.
Sex-based discrimination covered, yes.
Gender, identity, whatever, with any sort of thing, when that's purely, oh, it's a man with long hair, that's not discriminating. That's, like how, like that's like saying any of the women here's straight, lesbian, bi, who happen to prefer wearing trousers to dresses and have their hair short, that they're discriminating on that basis instead of the basis that they're lesbian or a woman.
I see what you're saying, but one of the things we were thinking of was, if we're going to put the argument to remove gender reassignment, then what about if people are genuinely unfairly discriminated against in something like housing? Should they have some form of protection on the basis that the only one that I would want to go for, of the ones that Alexandra Astoriti has suggested, is the belief one. I wouldn't want to go for sexual orientation as a sort of proxy for gender reassignment, and certainly not for one that I don't think I want to go for gender dysphoria as a disability either, which has also been suggested. But the fact that they believe that about themselves, that seems to me it's not recognising it has any objective reality. It's just recognising that's what they believe. But the fact that they believe that leads them to behave in certain ways and dress in certain ways, some of which are objectionable and some of which we wouldn't want to protect them around, like the men with their fetishes, whatever you want to call them. But I think women who identify as trans can potentially be discriminated against for that reason. And I wouldn't want them to have no protections from discrimination.
I think those people already have protection. I mean,
I don't know that they do.
Well, from the Maya case, Maya Forstater case, where it was said that a belief in gender identity is a protected belief. I think so is the belief in gender identity.
Yeah, it's protected. It's a protected belief. So
they are already protected. So that they are, in practice, they have that protection, whether we want them to or not. I mean, if you're going on the basis of belief, my understanding is that
they do
gender critical belief.
Actually, that's not quite.
No,
that's the implication of what they said in the Forstater case. It wasn't actually what the court said.
Yeah, no, it's true.
What they said was gender critical beliefs are protected, and they seem to suggest that it also worked the opposite way around as well. But that wasn't the finding, because that wasn't what they were looking at. The courts don't make findings about things they were looking at.
Can I just?
But yes, I see what you mean. But anyway, I think I see your point, and I see the point about should you be protected because you've got a sexual fetish. I see that point, and I don't know. I think we need to think about it a bit more. But what I wouldn't want is for women who, for whatever reason, have decided that they want to be men, don't get, and if they do get any kind of discrimination because of that, or if they get certain types of discrimination, like housing discrimination, because of that.
Okay, so I had a question, which was just when my dad in the 1980s had his letters from the psychiatrist saying, I want to use the women's toilets because I'm a transsexual and I have a diagnosis of transsexuality, and here are my letters from the psychiatrist, right? And he went into toilets. Was he breaking the law?
He's not breaking the law anyway. No, he's not breaking the law. Who might be breaking the law if they're meant to be single-sex spaces is the provider of the toilet.
So I know his employer actually put him on secondment because the women at his office did not want to use that.
That's for his employer.
I know, it's an amazing thing, isn't it, to think about that now. So is at any point he hasn't been breaking the law?
No, and even now,
now he isn't.
Now he isn't either. The reason it's difficult, one of the reasons it's difficult to implement the law to stop the likes of Robin Moira-White coming in and out of toilets is he's not breaking the law. He's undermining it. The person who's responsible for ensuring the facility is women only is the provider. So the obligation is on the provider. So your dad's employer might have been breaking the law. The law is